Mhm.
Welcome, everybody. We'll be starting in a couple minutes, so just sit tight. I'm on mute. Cardinal rule of Zoom. I did it. Good morning, everybody. I'm Dean Zenek, president of the Palm Beach County Bar Association. Thank you for joining us today. Thank you for joining us today for our town hall with Chief Judge Krista Marx. We are going to talk about hot off the presses, the new administrative orders regarding moving cases in Palm Beach County. I will defer to Judge Marx. We'll get started because I know everyone has a lot of questions. If you do have a question, please put it in the Q&A or chat feature. We've already got some submitted questions, but for right now, let me just have Judge Marx start with where we are and where we're going. Take it away, Judge.
Good morning, everybody. Nice to see you. Well, I can't really see you, but it's good to be here again. And I feel like this has really helped for us to be able to communicate in this way with the many changes that we've been going through during the pandemic. For the last couple of months here in the courthouse, it hasn't been radically chaotic. We have everything pretty much in place, and it's just been a question of opening up the courts a little bit more with regard to hearings where individuals want it to occur in person. So certainly discretion has been expanded with regard to the division judges and decisions they're making with regard to what will be held in person via everything having to be conducted remotely. So that's been a pretty big change. We haven't entered phase 3, but I fully anticipate that's going to happen here in the next couple of months. I would say sometime in June. We can't say unequivocally because, as we know, things can change on a dime. But based on the numbers and the Supreme Court administrative order, which indicated the biggest hurdle for us with regard to entering phase 3 was whether or not vaccinations are readily available in the community. And I think that threshold question can be answered positively for Palm Beach County. And again, we'll have several more weeks to make sure that a lot of people are getting vaccinated. So it seems certainly from the tone of some of the questions that were submitted early that everybody is pretty much on the same page of wanting to move forward and to get back into some sense of normalcy. And I think we have all done a fantastic job staying on top of our caseloads and conducting business the best that we can in this new era, but that it is undeniable for the trial courts and for the trial lawyers that we need to get back into the courthouses and start conducting in person some of these hearings. That as wonderful as these remote platforms are, and that we will continue to use them in some form going forward, that it's just essential that we start getting back into conducting more hearings live and in person because of the volume of evidence because of the credibility assessment of having witnesses present in front of you. There's myriad reasons, but we all know this. The trial courts in particular need to get back into the business of conducting business in person. So one of the big changes that is coming, and the AO went out yesterday, and we'll be getting that out to a lot of the bar leaders throughout our county. It'll be posted on our website. I am confident that many of you read the Supreme Court AO that came out with regard to all civil cases, and this mandate that we're going to have case differentiated management in every single case moving forward throughout the state. So that has been a mammoth project. We've got a committee here at the 15th that has been working arduously to get that into place and to do the best we can to make sure that it's consistent and easy for the bar to figure out what is mandated. And I'm happy to answer any questions that you have about that. I think the first place to start is to read the AOs, which are pretty self-explanatory, but it's basically this. In every single case moving forward after April 30th, there will have to be a case management order setting out the guidelines based on a determination of whether it's a streamlined, general, or complex civil case. And that holds true for the retroactive cases, which we tallied at about 38,000 cases. But we have till December to get case management orders out on those cases that are presently pending in the 15th. We were also able to cull out a lot of those from this necessitation of getting a case management order done in each of those cases, because a lot of those already have trial orders in place and foreclosures, other types of cases we were able to parse out to really whittle down that 38,000 number. And we've got a little leeway in getting it done on those cases that are presently pending. But it's going to be a mammoth task, and we're going to all have to pivot and just know and understand that this is the way it's going to be, not just here on the 15th, but throughout the state. The promise is, this is what we've been told, that the cases will resolve quicker, more efficiently, more expeditiously, that once we get this going, that we're all going to like it. And, I say this all the time, we resist change, it's just human nature, even if it's going to be for the better. And I think that the more time that particularly our committee has had to absorb exactly what this means, and through talks with other people throughout the state, they've been doing it in Miami, they've been doing it at the 20th Circuit over there in Naples, that they're finding it's beneficial for those reasons, that it really will help people resolve their cases in a more efficient manner. So I think once we all get on board, and we get over the initial shock of we have this great new task to take on, that it's going to be a good thing. So there are definitely changes coming with phase 3 and with this CMC directive from the Supreme Court. And I'm happy to answer any questions that I can to help you understand where we are and where we're going.
All right, Judge. So the first question we got, and I think you had been copied on before, was hearings. So how do you envision the difference in hearings between phase 2 and phase 3, where we are now versus when phase 3 hits? What will be the differences?
Well, as you know, we've been in phase 2 for a really long time, and we have tweaked our administrative order throughout that process, expanding or sometimes even narrowing what the guidelines were, depending on what the COVID numbers were. So, we obviously watch the COVID numbers every single week, and that's some of the benchmarks that we have to look at when making decisions. But, I feel like based on the positivity rate here and also the availability of vaccinations, that we're going to be doing nothing but moving forward and loosening up the guidelines with regard to, I think operationally, what you're going to see in phase 3 is that will allow more people into a given courtroom. With regard to mask, I have some strong feelings on the mask issue, but that comes directly from the Supreme Court. So until such time that the Supreme Court allows us to have any discretion with regard to masks. Here's what my thing is. I feel like in jury trials, it is difficult for some lawyers to proceed with a matter when all witnesses must be masked. I know we've spent tens of thousands of dollars with plexiglass and getting the courtroom socially distanced and making sure all protective measures are in place, and witnesses are far away from everybody else in the witness box with 3 sides of plexiglass. So what I would really like to see is for witnesses to be able to remove their mask once they're behind that plexiglass. And I think that that could make a big difference for us with regard to trials moving forward. When we move into phase 3, as you know, or maybe you don't know, the public has been banned from all of our courthouses unless you're here for official court business. Despite that, just here in Maine, we have nearly 9,000, between 9,000 and 10,000 people, sometimes a week entering the Maine courthouse. So that was a step I had to take early on to ban, supporters, onlookers, people who, were coming down here for reasons that they didn't have when they didn't have official court business. So I know there's a demand to get back into the law libraries. And again, with regard to trials, there are instances where people want the love and support of their friends or family, or, even lawyers wanting to have, their clerks or their associates be able to come and observe. So we'll be loosening that up as well.
And along with that, once we do hit to phase 3, and we don't know when that's going to be, obviously, but is there still going to be the residual, one of the questions talking about a tug of war between maybe some parties wanting to be live, some parties not wanting to come into the courthouse? Is that just going to be a judge by judge decision as far as whether or not there's going to be forced live hearings? And let's avoid trials right now, but forced live proceedings. Like you said, Zoom hearings are great, but like yesterday, you can't upload audio clips to the exhibit portal. So trying to play it through Zoom sometimes doesn't work out. So obviously, there's a lot of cases where Zoom hearings just aren't going to work. Once we hit phase 3, is it still going to be left up to each judge to determine whether or not it's going to be Zoom or not, or are we just going to be full bore back in the courthouse? I guess would be the question.
And Dean, it's funny because, the way you phrase it, will they be forced to come in person? And like I started off saying, people are on both ends of the spectrum when it comes to this issue as well. So there's plenty of people who would put that sentence of, will we be forced to continue to do this on Zoom? So, versus will we be forced to come in person? So that is and has been largely within the discretion of each of the trial judges. So several iterations of the AO ago, I loosened up what can and cannot appear in person, giving a lot more authority or discretion to each of the judges to determine when remote proceedings really weren't viable, whether that be because of the amount of evidence that was being presented or the particular difficulties of one witness or another, that there were lots of categories that we loosened up with regard to a judge being able to say, we're going to go ahead and do this in person. So it's going to continue to be that way, that, we saw the Supreme Court AO going from you must conduct hearings remotely to you may conduct them remotely. And we'll wait and see what the next use of language is with regard to that. But I think by and large, for a good bit of time to come here, it's going to just depend on what judge you're in and what type of hearing it is, whether it will be in person or remote.
And will there be any difference? Because we've gotten a lot of questions about family and family mediations. Is it really going to just be across the board, or is there going to be any type of differentiation between family cases and family mediations? Or is it just going to be, again, by judge, by division, depending on how the case proceeds?
Well, in family, I would say that perhaps they have the largest discretion with what hearings can be conducted in person. And so, anything that's domestic violence or stalking or any type of injunction hearing can be done in person. Um, you know, all bench trials can be done in person, all contempt, all sorts of hearings in family. I think probably more than any other division has the discretion to conduct them in person. So when it comes to mediation and deposition, this seemed to be a big question that was posed prior to this town hall. That's really not within the purview of the chief judge or the trial judges. Mediation and depositions, unless it's through our ADR office, and that's a different story. But those are matters that the parties should stipulate and agree to. Now, we all know that doesn't always occur, and sometimes there has to be court intervention with regard to location or time or place and so forth. But I think, when you look to the rules, and they haven't been amended, that there has to be either a stipulation to conduct it telephonically, or to, I don't know, could that be expanded to mean any remote means of conducting a mediation or a deposition? Remains to be seen, but it seems to me it has to be by stipulation of the parties that it can be conducted remotely. And if it isn't by stipulation, then you can set a hearing to say that there's some extraordinary reason why it must be conducted remotely. So, I just think we go back to looking at the rules for depositions, and that's, rule 1.300 and 1.310, which say, unless it's by stipulation of the parties or by specific court order, you don't conduct the hearing telephonically. And I imagine that would be broadened to mean remotely.
Yeah, and I guess we kind of forget pre-COVID era, but in regard to depositions, I used to take phone and video depositions all the time and didn't really flinch at it. Now, everyone wants to get back live so quickly that it's like, well, I don't want to do it virtually. I want to do it live. Can you force them to do that? And obviously, like you just said, it's really up to the parties, and if they can't stipulate, go to the judge and have them figure it out. But
let me say this. We don't want a bunch of hearings on people coming in and saying, all right, on your 845s, you're going to have 15 hearings to determine whether it's going to be conducted remotely. I really think, as we get into phase 3, that perhaps on each judge's webpage with their divisional instructions, it will give, this is where we start. We're looking at rule 3.10 and rule 1310 and saying that it shall occur in person unless it's stipulated by the parties, and that it really should be an exceptional reason why you're bringing it before the court, whether it be someone's health or something like that. So we don't want, an inundation of this party wants all the hearings to be remotely and this one wants them to be live. We're obviously already facing that, particularly in the criminal arena, and I sympathize with it. There are key witnesses that the defense wants to depose live and in person. So, for that reason, in our witness management office here on the fourth floor, and also we've opened up all 11 rooms, and we can accommodate up to 6 people at any given time. So just in the last few weeks, I've opened up all of those rooms because I understand it and appreciate that there are times when, as great as remote is, that in person is better.
Understood, Judge. And I think we've addressed this before, but I think it bears repeating. For non-evidentiary UMC hearings, I'm assuming virtual and Zoom is going to be around for a while. Is that fair to say?
I would certainly think that we're going to hang on to that for a long time. I think that it has helped the parties and, saved all sorts of costs for everybody involved to have to come all the way down here and find a parking spot and sit around in court for a couple of hours for a 15-minute hearing. I would fully anticipate that we're going to continue to do hearings such as that for a long time to come remotely. But again, there might be, a particular judge who believes that, based on any number of reasons, the conduct of the parties or the nature of the case that it could be in person. But I would say largely, I would anticipate UMCs will continue to be remotely for quite a while to come.
And sort of along that line, the electronic signatures, public notary, DocuSign issues that were given some lax rules. Do you foresee those staying on? Have you heard anything from the Florida Supreme Court about that? Once phase 3 happens, is anything going to change in that regard?
Well, that wasn't a result of an administrative order or anything judicial at all. It was a statutory change in 2020 with regard to the allowance of electronic notarization. So I don't imagine that statute's going to get changed anytime soon. So
okay,
yeah,
that's the answer to that question.
Yeah.
Now with phase,
I didn't know the answer to that either until somebody asked me the question, and my brilliant April Bristow, general counsel, was like, well, duh, it's a statute.
Well, yeah. So we both had that question in advance. So I'm glad you did some homework and got the answer for it. All right. So right now we're about 2 to 3 cases a week or 4, depending on. I think the other day I popped on. I think there were 5 Zoom hearings or Zoom trials that were able to be seen. Is that number going to stay the same until we hit phase 3, and then once phase 3 hits, it's going to open up more? I'm assuming, or do you anticipate before phase 3 we're going to keep opening more and more? But I think the limitation that you had with doing the trials was getting the jury pool in socially distanced areas. So I'm assuming that's going to stay the same until we hit phase 3, but you can tell me I'm wrong.
Well, presently we have the capacity to do 13 trials a week with regular size panels. And by that, I mean that we have an administrative order that dictates how many jurors per case, depending on what the case is. So if if you look at that administrative order, for example, if it's a felony, the standard for a second-degree felony is 24 jurors. So any cases that can fit within the confines of the number of jurors dictated in the present administrative order, we can do 13 of those. And we can do 2 large panel juries on Thursdays and Fridays a week. So we're up to 15 jury trials a week without there being much strain or stress on any of us. We've got it so down pat now. And we have a first-degree murder with 12 jurors scheduled for later on this month. And we also have a tobacco case that Judge Curley is planning on teeing up here in June. So here's the thing, we can do up to 15 jury trials a week, and yet we don't have the demand for that. So day after day, I'm sending jurors home because I got no place to send them. The summons have to go out 4 weeks in advance, so we can kind of get an overview of what we think we're going to need on any particular day. And I know that, we have Monday, Tuesday, and Wednesday are designated to particular divisions, with Thursdays and Fridays designated 1 judge, 1 panel, 1 trial. So we're bringing in, up to 100 jurors we can bring in the morning and in the afternoon for a big trial, like a tobacco case or a first-degree murder case. And we, we did 5 jury trials this week. Like I said, we could have done 15.
Okay.
So we're ready. Are you ready?
Well, that's a good question to ask everybody out on the thing. Everyone's complaining about not getting the trials, but like you said, we've got the capacity. We're not using it. So there's 147 people on this call today. So I guess our credo is set your cases for trial and let's get them set, right?
We're ready for you.
And I would imagine it's even before phase 3. I think as people get more comfortable, over the summer, it's probably going to pick up the demand. Hopefully will pick up as well.
And oddly, we're still getting a lot of, we need a continuance. We haven't done the depo, and, so same as it ever was. So I think, the judges would say they're calling up lots and lots of trials and are having a hard time getting trials to tee up. So I would say to the bar, you got something you're ready to go on, then get on in there and tell the judge and we'll get you a trial. The jurors have been awesome. Our yield rate has been great. And it's been running smooth as silk. And we have the capacity to send up lots of jurors, and we're just not having the demand.
Okay. And again, everyone on the call, if you have any questions, please type them in the Q&A feature. We've got a couple questions left, and then I might have a couple extra, but we have plenty of time. So please ask any questions you need answered. So vaccinations, is there going to be any type of, they talk about passports and all these other things. Is there going to be any type of vaccination requirement or showing of any vaccination thing by the judges or by the court for entry into the courthouse or for trials or anything like that?
It's an interesting question. I actually had this idea of, we've got some COVID dollars and getting stickers that say vaccinated or vaxxed on it, that the judges, because the vast majority of our judges have received both vaccinations. And they do a lot of talking. And they're far away and they're behind plexiglass. And I know that, for comfort, particularly when you're in there all day, some of the judges would like the availability of removing their mask when they're that distanced. And a lot of it is optics. So I had this idea of, let's send some optics. Let's send a message that the person is also vaccinated. And again, I am feeling that we're stymied with regard to some of the witnesses not being able to remove their masks behind plexiglass. I know we've watched some national trials that have been going on here in the country, and you'll notice a lot of those judges and those witnesses aren't wearing masks, and it's just different here in the state of Florida, and that we have a mandate from the Supreme Court with regard to masks throughout the courthouse. So we obviously comply with that. And I think the courts don't want to dip their toe into the political issue of vaccine mandates. We all know and have friends who feel strongly that they don't want to get vaccinated and are perhaps offended even by the question. So I don't think there will come a time when we will require it or mandate proof of vaccination. So this suggestion I have of easing back into it would be completely voluntary. You can either continue to wear your mask 100% of the time when you're in the courthouse, or that possibly you would have an opportunity to show in a visual way to others that you've been vaccinated, and at least on the witness stand be able to remove your mask. I think a lot of lawyers are taken issue with moving forward on big hearings when all you can see is the eyes of the person. And I get it. I think it is a big deal. I think there's a lot of there's a lot of communication that goes on via being able to observe somebody's face. So, that's just an idea. It's going to be up to Chief Justice Kennedy at the end of the day, and whether or not, like I said, I think we all saw that the governor said he's extending for 60 more days, and then the state should be prepared to move back into non-emergency status. So we can all read into that what we want, but his message seems pretty clear to me that 60 days hence, things are going to change here in the state. And we'll see what the Chief Justice says with regard to that issue. That was a long way of telling you, no, we in the courts will not mandate seeing your vaccination card.
You talked about the masks and seeing their faces. I had seen something, I guess, I don't think it was in Florida. I think it might have been somewhere else, but talking about see-through masks. Has there ever been I thought we had talked about that maybe at the last town hall as well. Was there any traction on getting see-through masks for the jurors?
Oh my gosh. We have so many. If any of you would like some see-through masks, it hasn't been a great endeavor. So we have tried repeatedly in all sorts of ways, and we have various see-through masks, and it's as simple as that. We are just they fog up, so you don't end up getting to see their face or their facial expressions at all, and that we are getting constant reports that it's even hotter than wearing a cloth or a fabric mask. So you feel like you're in your own little private hothouse. And so we have not had much luck with the see-through mask at all.
Understood. And when I watch the Zoom trials, we don't get to see the jurors, so I didn't know that was going on. But so you have them, you give them the option, but most of them don't take it. I guess is the point, because they're
right. And we have them available for all the jurors and for all the witnesses. So Some judges do call for them, but, obviously they report back to me that it's not a wild success.
Gotcha. Now, when we go to phase 3, the amount of people in the courtroom will be allowed to increase, correct? Is that
Correct. Yes. I fully anticipate expanding that number. Exactly what it is. We don't just come up with a number, we do walkabouts and we go into each individual courtroom and figure out what we can safely do. But I not only anticipate allowing there to be more people in a courtroom, but in conjunction with that, allowing spectators and onlookers and, opening up the law libraries and that kind of thing. So we'll continue to watch the numbers. I get the numbers every week of how many people are entering each of the 5 courthouses. And we want to make sure we don't go from 10,000 to 20,000 over the course of a couple of weeks. But yeah, I think we'll loosen up on, with the 3 feet at schools, and that issue continues to be bandied about. And as more and more of us become vaccinated, it just makes sense that, more people will be allowed in the courtroom.
okay? And because I know in a complex trial, you have a lot of lawyers and a lot of witnesses and everything with the jurors. I think some of the courtrooms can't handle that. So, but would the judge be able to then move it to another courtroom if it was a complex case that required?
Well, we had 2 ceremonial on the 11th floor at the ends of the halls, 11A and 11H. So 11A is basically our only courtroom that isn't presently assigned to a judge. And so we're going to keep it that way because that's where we're doing jury selections. Some of the jury selections for civil can easily be conducted downstairs in the jury assembly room, where in the main room we can accommodate socially distanced, with even today's guidelines, 75 people and up to 100 people in the anti-rooms that are connected to the jury assembly room. So in civil, like in this tobacco case that Judge Curley's planning on doing, the jury selection will occur there because the court reporter can be present and all the lawyers can be present. We don't really have that availability for the criminal cases because we the court are the keeper of the record and we have to make sure everything is recorded. And secondly, we can't very well traipse down the incarcerated accused down to the jury room. So we're more limited in that way. But in courtroom 11A, one of our ceremonials, we've taken all the desks out and we can accommodate at one time up to 40 prospective jurors in that courtroom. So certainly for some of these bigger cases where there's lots of lawyers and so forth, we are, doing like eviction notices to the judges who are in the bigger courtrooms to get out and go elsewhere so that we can make sure everybody's spread out and safe.
Okay, so I guess the question is, if you have a complex case, go to your judge. If they have a smaller courtroom, and tell them you're ready for trial, and they can hopefully get you into a bigger courtroom to get the complex case tried, right?
We'll get it done. We will get it done.
All right, great.
See, that's the luxury. I tell some of the judges that are assigned to the big courtrooms, good for you, and you may or may not enjoy it. I certainly spent years in one of the big courtrooms, and it's got its downside too. But one of the big downsides is if we need it, you got to pack your stuff up and hit the road.
All right. So we're kind of going back to the mask issue and the protective things. We've got all the plexiglass set up. I obviously spent money on that and got everything set up. Do you anticipate that staying around for a while, even if we go to no masks and stuff like that? Or do you anticipate if we go into phase 3, some of that stuff's going to come down or anything like that?
Well, I don't want to speculate because, again, it'll be up to the Chief Justice what he wants to do with regard to the mask mandate. I think we probably have a pretty good idea what the governor is going to do. I'll leave that to each of you to decide what you think the governor is going to do with regard to mask here in the next 60 days. Like I said, he just came out with an executive order on the 26th, I believe, 26th or 27th a few days ago. And I have talked to Justice Kennedy about that, and I don't know. I would speculate that it's not going to remain a mandate that masks must be worn at all times when we start getting into phase 3, because again, the premise, and before permission is granted to enter phase 3, we've made the determination that vaccinations are readily available and that, by and large, people in the community have been double vaccinated. So I think we're just gonna have to wait and see what the Supreme Court says on that.
And that would obviously trump whatever, because I know Palm Beach County just extended the mask mandate for 30 days. That was a week ago, I think. So I mean, if the Palm Beach County mask mandate ends before, we'd have to wait for guidance from the Supreme Court though, correct?
Yes. So the courts are completely different, and, we take our direction from the Supreme Court.
Okay, so even if there isn't a mask mandate here, we would still require it if that's what the Supreme Court says. Because I know that may be a big question that's asked of people at the front door saying, well, the Palm Beach County lifted the mandate. Well, we're not under that. We're under the Supreme Court. So you need to put your mask on until such time.
It's going to cause a little controversy, I'm sure. There'll be, some contentious conversations down there, particularly if Palm Beach County lifts it. And, it's funny, like in the beginning of this, we used to post the AO and I'm like, nobody's going to read the AO. We just have to have signs that say, it's mandated by administrative order that you must wear a mask. So yeah, it's going to get complicated if they lift it statewide or countywide, and we don't do so in the courts. But at this point, we have no discretion.
Okay. This is a foreclosure question. With the anticipated tidal wave of foreclosure filings, is there any consideration of restarting the foreclosure division from back in the day?
No, not at this time. I will tell you this, Judge Zuckerman is presently our trial division judges, where, as I stated earlier, we don't have a hot demand for a division that strictly does trials because we're just not having the demand right now for jury trials. And so she has been handling foreclosures and termination of parental rights. And so the utilization of the trial division, I think we'll see foreclosures continuing to be handled a good deal in there rather than in the 12 civil divisions. And also what we have not been able to utilize during the pandemic is senior judges. So we have not brought a senior judge in to conduct any business since March of 2017, because by virtue of the word senior, I just didn't feel that was a safe step to bring in those judges to help us out. So we'll definitely go back to utilizing senior judges, I would say in phase 3, when we've made the determination that we're safe enough to utilize them.
Since we keep bringing up phase 3 and the question has been asked, and I know the answer, but for everyone that's not out there, and I know the answer is you don't know. The question is what is the anticipated start date for phase 3? But you can expound on the I don't know answer that I'm assuming you're going to give.
Well, we have to submit our plan to the Supreme Court. And, my best estimate is that will occur in the next 60 days, that I hope to move us into phase 3. I'll be speaking to Chief-elect Judge Kelly, for him to weigh in on it too. But just because we move into phase 3 operationally, other than allowing more people present in the courtrooms, I've got a list of things that are going to immediately change when we move into phase 3. The biggest difference will be that once we enter phase 3, we'll have an additional 90-day stay for the speedy trial clock before it starts. And then thereafter, we'll start looking at the speedy trial running again. And I am of the opinion that will be helpful to start getting some of these circuit criminal cases tried when the speedy trial clock starts to run again. So I think based on our numbers, and we're having a chief judges meeting this week, in fact, to talk about phase 3, and some of the other circuits are poised to move into it as well, that will occur before the summer, but I can't give you a definitive date. And like I said, things could change.
Well, that was a good segue into my next question, because you said you're meeting with the chief judges locally. How with our new AO that just came out yesterday, how is the coordination between Martin, Broward, and Dade going to be? Because a lot of us, practice in those 4 areas. We've got Miami lawyers coming up, Broward lawyers and whatnot. Are the chief judges working together to make sure that, I know we've got the Supreme Court AO that everything needs to follow, but I'm sure there's going to be tweaks here and there. Are you guys working together, I guess, I'm assuming, to make sure that there's kind of a seamless cohesiveness to, South Florida, as far as, all of these different AOs are going to be coming out?
Well, we have all been sharing our administrative orders and talking with one another and having meetings. We have a meeting scheduled on May 21st for each of the 20 circuits to talk about implementation of the new CMC directive. And, certainly I've had communications with Judge Merman and Judge Tudor and Judge Soto. In the 11th in Miami, they have been running a pilot program for a good period of time already with regard to this. And so this is what I would say: in every single civil case, no matter what circuit you're practicing in, there will have to be a joint stipulation as to, what track it is, whether it's simple or general or complex, and that the parties are going to have to agree on a timeline that's set forth in the administrative order based on your designation of the case. And then we're going to, on our end, have all sorts of case managers who are tracking that to make sure that it was submitted and that the court will be privy to it and try to hold people's feet to the fire with regard to what those deadlines are. So that's going to be uniform no matter where you're practicing, because if you delve into that AO a bit, you'll see it's not, it's pretty much, here's what the guidelines are, here's what the timelines are, and everybody's got to comply. So I know this in Miami, if you don't get that joint stipulation in or agree to the track and the timeline and submit your order, which has to be adopted by the court, then there will have to be a case management hearing so that the court can make the determination of what track it is and what the timeline is going to be. And we have no way of knowing, once that order goes out, what kind of compliance we're going to get. So, the big goal is not to have a whole bunch of hearings, case management hearings to make these determinations. We're hoping that the parties will work together and to be able to submit those orders for the court to adopt. There will have to be case management hearings for those where it doesn't occur. But I don't think you're going to find a huge variance from circuit to circuit with regard to implementation of this new mandate.
Okay, and is there timeline? I guess the timelines are set by the Supreme Court AO, right? So everyone's got the same.
Exactly. So
and
we're in it. So starting tomorrow, April 30th, every summons that goes out will have an attached standing order dictating to the parties that you must submit this case management order. And then we're going to track it on our end. And for those parties who haven't done it, you'll then get notice that there's a case management hearing, upon which time I'm sure plenty of people will kick it into gear and get the case management order done. But yeah, starting tomorrow, today's the 29th. So starting tomorrow, those every summons that goes out will have the standing order signed by the administrative judges of circuit civil and county civil saying, here's what you need to do, and you need to get this order and this stipulation in, which will be adopted by the court, and failure to do so will result in this additional hearing. But what we're hearing from Miami is that mostly it gets done. So there aren't, I would imagine for those people who didn't comply, there'll be quick dockets, it'll be getting the people in there for 15 minutes, I guess, and saying, go out in the hall and figure this out, or it's not going to be really long hearings. But again, I think you're going to find that's true for all the circuits, because if you read the AO from the Supreme Court, it's not a lot of discretion.
And actually, that was sort of going to be our next question that we got was the case management plans. for individual judges, is there any room for them to tweak it to, because I know typically before COVID, each judge had their own little, they certain ways of submitting things or certain forms they wanted to be filled out. Is the form that was attached to the AO yesterday, is that the form, can't be tweaked at all, or can the judges have the ability to add stuff to it, delete it, or anything like that? Or does that just make it a administrative nightmare for you all?
Well, yes and no. So for example, there's certain things that have to be consistent because the case managers are addressing so many cases. So with regard to, extensions of time for service, that's going to be consistent throughout the divisions. But there might be particular judges who want to add things to the case management, to the orders. And so the attached orders, which were largely done by Chief Judge-elect Kelly, he sent it out with the proviso that you individual judges maintain your discretion and can tweak them as you see fit. I'm hoping, for the sake of all of us, as we get rocking and rolling on this huge new change, that everybody tries to stay relatively consistent, at least in the beginning, because I think it's going to cause a lot of upheaval and confusion here right out of the box. But the judges, of course, always have discretion to tweak it as they see fit. And maybe that'll just be in particular cases, depending on the parties and the complexity of the case or whatever. But, I think we're all hopeful that there aren't going to be huge variances from division to division.
Okay. I'm just looking at, any idea when 12-person jury trials will resume?
I've got one in 2 weeks. Judge Caroline Shepard is planning on doing a first-degree murder in May. So my answer is now. We are ready for you, people.
I think there was a question about ventilation in the courtrooms and things like that. I know you would, maybe not the last one, but the one before, you had talked about there some equipment that had been purchased by the courthouse for ventilation. Is that right? My memory serving me correctly?
Yeah. Before I leave that 12-person jury question, and as I stated earlier, we do in fact have a first-degree murder that we're getting ready to do here in May, and a tobacco case coming up here shortly. But both of those had to be specifically approved by me as the chief judge. So I don't want to overstate. We are not really ready right this minute to start, taking on all of those mammoth cases. And in each of these scenarios, the trial judge, Judge Shepard and Judge Curley, convinced me that there were reasons why we should go ahead and do it. And throughout this process, I've liked the idea of starting small and measured so we can figure out what our big issues are. It's going to be complicated for them because we're going to have to stagger jurors, bringing in 100 in the morning, 100 in the afternoon, sometimes over a 2-day period before they'll be able to get those panels seated. So, but we're also going to be moving into phase 3 here. And I sure hope come, the fall that these aren't going to be as pressing of issues, because we're going to all feel much safer and sounder and really be able to start teeing up some of these larger trials. So we do remain ready for almost all of your trials, but I don't want everybody with, a gigantic 6-week med-mal or those kind of cases that, probably fall. Or if there are extenuating circumstances, there might be reasons why we'll let you do it here in the next couple of months. As to ventilation, yes, we have purchased many air purifier machines. So within every jury deliberation room, we have them. We have several in the grand jury room. And we hope that's another layer of making everybody feel safe and sound when they're here. For some of these big, for the first-degree murder and for the tobacco, those will be conducted in the big ceremonial courtrooms, and jury deliberations and breaks, extended breaks and so forth will occur within the courtroom. So we won't put 12 jurors in a standard jury deliberation room at this juncture. We'll lock down the courtroom and turn off the sound and let them deliberate in there.
And so right now, jurors can get out of service by saying they're fearful of COVID, right? That's still an option. We're still getting jurors, but that's still an option for them to not serve. Is that correct?
Well, we have what I call the COVID-5. So that is like you've had symptoms, you've been around somebody who has, you've traveled internationally. So those, we call those people out even before they come downtown. And then every single week, I get a big stack of letters for people who want to be excused or postponed from jury service. And many of those are because, they got unnecessary anxiety or things like that associated with COVID. And we have been extremely lenient. And then once the jurors get here, a judge goes downstairs and does what we call a pre-voir dire inquiry. And one of those questions is, are you just so anxious about COVID that you don't feel you give us your attention over the course of the next couple of days for this trial? And again, we've been extremely lenient with regard to those types of excusals and postponements. But we saw in the last AO that Justice Kennedy is starting to say with regard to continuances and not being ready or not wanting to come to court, that we, the trial court, should no longer be accepting pure COVID pandemic excuses. So I would certainly think with regard to juror excusals and postponements that, we're going to start to see the trend away from all you have to do is put your hand up and say, I have COVID fear, and get out of it.
Is that going to be like a phase 3 thing, or do you think that's going to start being implemented before phase 3?
Well, candidly, I review all of those requests. Other than you absolutely can be excused if you are experiencing symptoms or you were, you're living with someone who has COVID, what we call the COVID-5. So those other kind of discretionary COVID requests for postponement and excusals are handled by the chief judge. Well, I guess my answer would be I'm not going to be as lenient here for the next few weeks. We'll see what Judge Kelly's opinion is of when he starts reviewing the jury requests for postponement and excusals. And, for the judges that go downstairs and do the pre-voir dire inquiry, I see a huge difference in numbers. So depending on what judge goes downstairs, sometimes they excuse 10 people and sometimes they excuse 2 people. So discretion is alive and well here in the courthouse.
Understood. Speaking of Judge Kelly, we have a question that's, and I don't know if even you know the answer to this and whether you're willing to say it or not, but do we know who's going to be taking over Judge Kelly's division once he becomes chief judge?
Well, no.
Good answer. I figured that was going to be the answer, but I figured I'd ask.
Well, because, we don't know who's going to take my spot. So we're going to be down a judge until the governor appoints a new judge. And, so for most of my 4 years as chief judge, there was a rare time when we had a full house. So there's almost always a hole in the circuit. And thankfully, we have wonderful judges who put their hand up and, jump in when we've got a hole like that. So I don't imagine it's going to be, there'll be a period when we're kind of cutting and pasting to cover a division. And I anticipate it will be Judge Kelly's division that for a minute, we're going to have other people covering before the determining, we got to wait and see who the new judge is. So, when it comes to assigning judges to a division, we got to know who we're talking about.
Understood, Joe. I read the AO yesterday. I read it again this morning, talking about all the different case tracks, and the deadlines. I mean, is there anything that's not in the AO that you want to communicate to everybody about, the different type of tracks, the complex, the streamlined, the general, all of those other things? Anything else that we need to be aware of that may not be in the AO? I'm sure it's got everything in it, but just from a practical standpoint for practitioners and trial lawyers that are on here, is there anything else we need to know that may not be in the AO that we should be, cognizant of when we're doing these scheduling orders and when we're going to the judge for things, when we're talking to the other side, trying to get agreements? going backwards on our cases, getting this done in the next 4 weeks, 5 weeks, all of those type of things.
Well, Dean, I would say this. Listen, when I first read it, I almost fell out of my chair. I was like, holy cow. And I think we all have varying opinions on how fruitful or whether this is a good idea. And so, maybe for the first couple of days, there might have been some moaning and groaning and kvetching about this. But here's the word. We didn't create it here on the 15th. It came down as a mandate. It is going to happen statewide. And I think once you process it and you start looking at it, it makes sense. And so once we all get on board, that we might find, hey, this really was a good idea. And we're much more efficient with the use of our time and so forth. And so I think my message would just be this: we're going to do it. So whether you think here at the outset it's a good idea or not, we all got to get on board and do the best we can with it. And I think once you process it and you start pushing it around a lot, it isn't as complicated as it looks. Trial orders basically address most of these things anyway. It's just we're all hopeful it's going to occur sooner and people are going to get themselves before a judge quicker.
Yeah, and I think you said earlier, because I guess my concern is, especially the older cases that we have to, I think, get it in by June 1st, getting everyone on board in that small period of time and agreeing to these dates, especially if we maybe have counsel that we're not as cooperative or something like that. But I think you said in Miami that the cooperation the level was actually pretty high and they weren't really having a lot of hearings on getting the dates done. Is that what you're hearing from Miami?
That's what they're telling us. Both the 20th and the 11th have already been doing this for quite some time. And so right out of the box, when we were all in that, freaked out mode, they were telling us, you'll be surprised. Not much time there's a lot of busy work. Trust me, the case managers here, there's a lot of busy work that's going to go into it. But I really think once it's implemented, we're hearing that it's going to be faster and efficient and that we're all going to like it and that it's not going to result in a ton of case management hearings. Time will tell.
Okay. Last question is, we've been talking about jurors and getting jurors in and jurors that maybe are fearful or anxious or whatnot. Have you seen any difference in the, I hate saying it political, but like the amount of jurors getting dismissed or let go or anything like that? I mean, is the juror, are you getting the same pool of jurors that we were getting before? And I don't even know if you have the ability to even track that or not, but I mean, is you're seeing a difference of jurors coming to the courthouse, I guess would be the generic question about that.
I really think that's a great question, Dean, and a really prevalent fear throughout the state that based on these COVID answers that we're not going to get a fair cross section of the community, that maybe we would be lacking the correct percentage of elderly folks or whatever group you think would be getting out of jury duty based on COVID reasons. But, our public defender came and sat through several selections, and certainly the judges have eyes on. And I would say, shockingly, well, maybe not. Maybe we just have fabulous citizens and I'm not giving them enough credit, that our yield and the show up rate has been wonderful. Sometimes outpacing pre-COVID numbers, which really does shock me. I can't figure out how we have better yield now than we did pre-COVID. And anyone who's watching, and a lot of us have a lot of experience seeing what those pools look like, would tell you that there isn't a variance and that we are continuing to get a great cross-section of the community. So any fears of that nature should be appeased by virtue of the fact that I can name, any number of judges. I myself, the other constitutionals that have been coming and watching would all tell you, no need to fear.
Yep. Well, that's a great answer. Thanks, Judge. I'm sure that puts people's mind at ease. And we are literally at 12 o'clock on the dot. If you can
Good
believe
job, Dean.
my board meetings don't do that. We're always over on the board meetings, but for the webinars, we'll end on time. But do you have any closing remarks, Judge, before we go, or it's up to you?
I would just say, I say it all the time, and anybody who knows me knows I say what I mean, and I mean what I say, and I don't sugarcoat it if it doesn't need to be sugarcoated. That the Palm Beach County Bar Association and the lawyers who practice in the 15th have just been incredible during this time. And like I said, I talked to all the other circuit judge, the chief judges throughout the state. Some of the things I hear, we really need to give ourselves a pat on the back here in the 15th. It's been a tremendous challenge, but the bar in particular has really risen to the occasion. And I would just say, hey, we miss you. We want to see you. Come down here and go to trial with us. We're ready for you. And I know from the tone of a lot of these questions, you're ready too. So get in there and let's start doing what we do. Let's start trying cases and get back to it. Thanks for having me. And I remain available for anyone who's got any questions or concerns about what's going on here in the court.
Well, thank you, Judge. And I guess you finished by saying, start doing all your scheduling orders, right?
Right. Get on that right away. We have form orders for you, so we are going to make it easy. And go to the 15th Judicial website. If you can't find it, we have posted all of those orders for your easy access.
Thank you, Judge, and thank you everyone for attending today. I hope we got to everyone's questions. Remember, Law Week is next week, so there's a lot of, please go to palmbeachbar.org, and there's a lot of Law Week things going on, and please do our coffee and bagel with the judges, which is a great thing, and look on our calendar for upcoming events, join a committee, and thank you again, Judge Marx, and congratulations again on a great couple of years, a great last year. It's been a pleasure working with you this year and getting us through this pandemic. So we all appreciate it. Thank you everyone for attending today. And everyone have a great rest of your week.
Thanks, Dean.
Take care.
Take care. Thank you.